several filings to the U.S. Supreme Court and challenges to Illinois' gun and magazine ban, and they come from the Second Amendment Foundation, and it's not the Barnett case that is currently in the Southern District of Illinois, consolidated with several other cases. Now you've got a couple of other challenges that were pushed to the U.S. Supreme Court to have them consider, and those are having some more filings there. So follow along with us. It's Bishop on Air. I'm Greg Bishop. Thanks for hanging out with me. Like, subscribe, hit that notification bell, and join us each and every weekday morning as we break down stuff happening in and around Illinois. But let's go ahead and jump into some of the latest from last week in the U.S. Supreme Court filings. Let's look at the U.S. Supreme Court docket page for the Barnett case, where you have, of course, it was filed February 12th, and we've reviewed all of the other filings here, even up to the 15th of this month, where Cook County responded, the state of Illinois responded, but you also had others that responded in amicus briefs, like the Sheriff's Association. So no movements there on that case yet. But if you look at some of the other cases where Attorney General Kwame Raoul is the defendant, in particular Javier Herrera's case and also Dane Herold's case, these are just two other cases that the U.S. Supreme Court has been asked to take up. And let's look at the Herrera case real quick here. That was filed also for cert February 12th. And this is the guy from Chicago and Cook County who was challenging Cook County's ban. And ultimately, that case in the Northern District, the judge said that the state had and the Cook County has a likelihood of succeeding on the merits. But we have a reply that was submitted last week in this case. And let's go ahead and pull this up, where it's in the U.S. Supreme Court on petition for writ. And let's see where we get here. The Seventh Circuit defied the court's precedents on a question of exceptional importance. The absence of decisions faithfully applying Bruin highlights the need for review, and no vehicle issue stands in the way of this court's review. So a brief filing here. It's only 19 pages, a lot of citing that's going on, but respondents' opposition confirms that the Second Amendment will remain a second-class right, and this is according to the reply, unless this court intervenes. New York State Rifle and Pistol Association v. Bruin. Dr. Herrera seeks to keep his common semi-automatic rifle and magazines in his home. Respondents prohibit him from doing so, even though this court has already held that states cannot categorically ban commonly owned arms in the home. District of Columbia versus Heller. As a result, he can't use his rifle for SWAT training, endangering himself and his team. Respondents do not dispute that they must justify their bans under this court's text and history approach, but they join the Seventh Circuit in rewriting the standard. On plain text, the reply in the Herrera case says, all firearms are arms, and they cite Heller. But respondents insist that Dr. Herrera's common semi-automatic firearms are not arms at all because they deem them too much like military-grade weaponry. So you can go through and read more of this and really just go and search the U.S. Supreme Court's docket page for Javier Herrera. And if you're not familiar with that case, it really stems from this doctor who helps with responding to SWAT calls, and he wants some own protection and has semi-automatic firearms. But in the states of Illinois, in Cook County, in Chicago, he could not even keep those firearms in his residence, so he had to store them, and he sued. Regardless of how you feel that particular lawsuit was written and delivered, the Northern District of Illinois federal judge sided with the government, saying that they had a likelihood of success on the merits there. So Javier Herrera looking to get his case called up in the U.S. Supreme Court. But you also have the Dane Herold case, and this is part of the 4 different plaintiffs' lawsuits in the Southern District of Illinois, where Judge Stephen McGlynn, he has the case moving forward on the merits, and some deadlines coming up in just about 2 weeks, where you've got another status hearing that's set, and filings on what kinds of experts the various litigants are going to call during a trial on the merits. And I think this is important, again, just to reiterate. So far, things have moved on preliminary bases and moving forward, including all the way up to the Seventh Circuit U.S. Court of Appeals. And that preliminary basis of the rulings ultimately have the Seventh Circuit Court of Appeals saying that the state has a likelihood of succeeding on the merits. But we have yet to get to the merits, those merits being dealt with in the Southern District of Illinois Federal Court, with a trial that's expected sometime in July. But you have the Barnett case, that's like the umbrella for these four consolidated cases all lumped together. The Herold case is part of that as well. And if you look at the docket for the U.S. Supreme Court, you'll see the Herold case there, filed February 12th, as we saw all these other cases being filed. But then you have April 26th, a reply on Dane Herold. And if you look at this document, here we've got the filing, petition for writ. This is coming from David Siegel and various other attorneys. And you have it filed here with some of the overview. The Seventh Circuit's decision conflicts with Bruin and Heller. This court should grant cert to make clear that history permits only dangerous and unusual weapons to be banned. And I think that's important there. Dangerous and unusual. I mean, by virtue of a firearm is dangerous, but is it unusual? I think that's an interesting debate that is definitely being had. But the opposition demonstrates the need for cert to settle this issue. This issue is fully developed, and decision below is representative of a growing body of decisions that conflict with the U.S. Supreme Court's precedent. These issues can be resolved in an interlocutory posture. So what that means is interlocutory means kind of, the case is still proceeding, for instance, down in the Southern District on the merits. And people are asking for the Supreme Court to intervene, interlocutory, before the full case is fully developed with the merits. People want the U.S. Supreme Court to come in the middle of it and to challenge this. So going through this just briefly here, and again, it's a 16-page filing in the Herold case. But some of the reply brief, and you'll probably hear some of the similar themes in the Herrera case. But respondents' briefs leave no doubt that the issue in this case is deserving cert. Respondents pile on the Seventh Circuit's ill-conceived opinion additional and typical arguments that fundamentally misunderstand how the dangerous and unusual test laid out in the District of Columbia v. Heller case works within the framework made explicit in the New York State Rifle and Pistol Association v. Bruin case. Though respondents urge that there are other similar cases pending below and that this court should delay consideration, in respondents' view, indefinitely, to let those cases play out, in fact, the opposite's true. Delay is likely only to permit existing errors to entrench themselves, and interest balance did before Bruin in circuits around this country. To avoid history repeating itself, this court should grant cert. So then it goes into the Seventh Circuit's decision conflicting with Bruin and Heller. And again, you can read all of this as well. Just go to the U.S. Supreme Court's website and search. If you search Raul, you'll be able to find the Barnett case, the Herold case, and the Herrera case, all of which are asking the U.S. Supreme Court to intervene before the case is fully dealt with. At least the Barnett and the Herold case is fully dealt with by the Southern District of Illinois federal judge Stephen McGlynn, who's handling that on the merits. So some interesting stuff happening late last week with those filings to the U.S. Supreme Court, asking that they intervene while you've got that Southern District case playing out. So hopefully you're staying up to date there and getting the latest. With Bishop on air, greatly appreciate you guys being here. A lot of comments in the live chat, so thumbs up there. Thank you for taking the time with us, as always, each and every weekday. So like, subscribe, and hit that notification bell, all right? Make it happen.